Good morning and welcome to the Phillips Wealth Counsel podcast. My name is Greg Phillips and my guest today is Frank DiPietro. Frank is an assistant vice president with the tax and estate planning group at Mackenzie Investments. He has extensive knowledge in the areas of personal income tax, succession planning, estate planning, and cross-border issues impacting Canadians. His primary role with Mackenzie is to work with financial advisors like myself to interpret tax legislation, to see how it might impact the financial planning objectives of our clients. And lastly, he's a regular contributor to a column with advisor.ca. So welcome, Frank.
Well, thank you very much. And thanks for having me.
No problem at all. How are things at Mackenzie? Pretty busy?
Things are going really well. Yeah, things are great.
Good. It's hard to believe that we're approaching the end of the year here. So
That's true.
It's been going quickly with COVID, right? So
absolutely. Yeah, it's been busy and the year has just flown by.
Right. I found that with COVID that, you kind of lose track of time a little bit more than in the past, right? Because
no kidding.
Everything seems a little bit like Groundhog Day. So, so anyways, tax and estate planning, great topic. And like I said, thanks for being with us today. When you mention tax and estate planning, for a lot of people, it's a pretty intimidating term. So why don't we start by you just letting us know what is tax and estate planning and how do we begin that process?
Yeah, it's a great question, Greg. Thanks. Taxes and estate planning really do go hand in hand. And when you think about individuals who are planning and doing their estate planning, one of the key objectives that they may have as part of that plan is to try to minimize tax. And really one of the reasons for that is thinking about how our Canadian tax laws are designed. We have it sort of hard-coded in our tax act that when we pass away, we're deemed to have sold everything we own. And so it's really Canada's way of taxing us one last time, before we move on. So, trying to minimize taxes as part of your estate plan is one objective that many Canadians find really important. And thinking about defining estate planning, when we ask Canadians about estate planning, they think about taxes, they think about, their kids and beneficiaries, spouses. But I define it this way, Greg. I say that estate planning is a process of structuring your affairs to preserve your wealth and to transfer your wealth in an orderly fashion to those that you choose. So, if you think about that for a moment, it's a process of structuring your affairs. So this isn't a one-time event that you set and forget. It involves continually reviewing that estate plan to make sure that it's current and it properly reflects your current wishes. It's about preserving the value of your wealth. There's two certainties in life. There's death and there's taxes. Right. So as we just talked about, estate plan is also trying to preserve that wealth and maximize what we leave to our family and other beneficiaries, and choosing those that you wish to benefit from your hard-earned wealth. So really thinking about who you want to leave that wealth to and how you're going to go about doing it. So, there's lots of steps to go towards in creating that estate plan. But fundamentally, it's really about working with advisors to start putting the plan together. And when I say advisors, it involves financial advisors because they may help coordinate and implement an estate plan. Right. But it's really any professional that may be involved in putting that plan together. So yes, a financial advisor, your accountant, your estate lawyer who's going to draft the wills and other documents you might need. Could also involve insurance specialists and others. So really estate planning involves coordinating and working with your advisors and setting realistic objectives in terms of how you want your affairs to unfold. Right.
So it involves a lot of people. It's just not a one-person show kind of so to speak.
Exactly. I think a lot of Canadians, they go to their lawyer and they get their will done and they feel like that's their estate plan. And there's a lot more to your estate plan than just your will. Of course, the will is extremely important, but there may be more to it than just that.
Okay. And you mentioned it's an ongoing process. Is there, from my experience, the answer is no, but it's worth asking you as the subject expert. That process, is it something you set up a schedule to kind of review the plan every year, every 2 years, every 3 years, or can it be more erratic?
Yeah, it's really based on everybody's circumstances. So as a general rule of thumb, we believe every 3 to 5 years is a general framework to at least review your wills, review your estate plan to make sure that they're current and that they properly reflect your desires and objectives. But also in the meantime, if there's any major life events, so
Sure.
if you've had a change in marital status, married, divorced, separated, if there's been any, deaths in the family, if if there's been a major asset that's been sold, a business or a cottage, for example. So any major life event probably triggers a need to at least review and
Yeah.
potentially update the will.
Makes sense. Okay, you mentioned something about establishing objectives in the tax and estate plan, and maybe you could go over some examples of what those might be and how you would best achieve those objectives.
Sure. Yeah. So again, this comes down to every Canadian individual and their own circumstances of what they want to achieve. So some of the more common objectives that we hear from Canadians is one, reducing taxes, as we've talked about. Very few Canadians who don't want to do that. But two, there's also many Canadians will say they just want to simplify their financial affairs. They want to, get everything under one roof, for example, and create a plan that just allows for a smooth and simple transition to the next generation, for example. Many Canadians will say they want to distribute their wealth equally or fairly. So fair may not be equal.
Right.
And so, you want to think about how that will be accomplished. Some Canadians have concerns around, how and when their kids, for example, may inherit, right? So some parents may be concerned about, whether the kids what they'll do with their inheritance.
Yeah. Are they ready to have access
Are they
to
ready?
that money? Yeah.
Exactly. And, if they're not, for example, financially mature enough or there are other issues, they may have concerns about, that money dissipating in a very short period of time. Some folks may have philanthropic objectives. They may have a desire to support a certain charity or religious organization. And that is an objective that if you want to achieve as part of your estate plan, really requires some thinking and planning in advance on how to go about doing this in the most effective way. Business owners as well. Business owners have even more concerns in terms of if they're sort of the primary individual running a business, they need to think about how is that business going to continue without them if something were to happen. And that's a daunting concern for a lot of business owners in terms of implementing as part of their estate plan a succession of the business. And that could, take several months or years to put in place.
And from what I understand, a lot of business owners, their biggest asset is the business, but have they done the planning and had the discussions that you're talking about? I think I've read articles where there's a huge percentage of them that have not. And, maybe they have one idea in their head that, hey, my kids are going to take this business over, but maybe none of them have any interest in that. And so therefore, they've got to look at alternative ways to pass those assets on. Is the business going to be sold? Is there a key person in that business that maybe they would leave the business to, et cetera? So it's not like, as you point out, it's not something you can, figure out on a Thanksgiving weekend quickly with your family and move on. So it requires some thought and a lot of professionals to kind of give you that guidance.
Absolutely. And I think on top of that, Greg, a lot of business owners, they're so busy working in the business that they that they say that they don't have the time to think about it, but it's really, it's extremely important. And a lot of, business owners would love for, the succession to the kids and have this intergenerational transfer of the business. But very few businesses actually successfully transition to the next generation. A lot of that has to do with the lack of planning that goes into that.
Right.
So anyway, I think for a lot of business owners as well, they may feel that one or more of the kids may not be ready to take over the business. And so that is sometimes used as a reason for not affecting a succession plan. But there's still lots of planning and things that can be done in advance, even before that child or children eventually takes over. So again, in this effort to have this smooth transition, to your point, it doesn't happen overnight. And there's a lot of steps that need to be taken for it to happen successfully.
Right. And it's like a lot of stuff. Start early, start the plan, whether it's financial planning, tax and estate planning, a workout regime, a nutrition, a diet. Start early. It all works. The earlier you start, the better. So,
Exactly.
As you highlighted, tax and estate planning can be very basic. Depending on the person's estate, naming beneficiaries and whatnot, but it can be very complex as well. So maybe you can highlight some alternative ways to transfer wealth to people's beneficiaries, and what's the best way of implementing those maybe more complex strategies?
Yeah, it's a great question. So when we think about transferring wealth to the, when we pass away, really the primary document, the real legal document that everyone should have is a will, right? And as I mentioned at the outset, the will, of course, will dictate, who will inherit your wealth, but it's not the only way, and it's not the only document that you can use as part of your estate plan. There are other tools or strategies you can implement. So to give you a couple examples, for one, we can use this concept of joint tenancy.
Right.
And joint tenancy, as the name suggests, is really this idea of owning an asset together with someone else. And this idea is usually indicative of what we call true joint tenancy. And the idea behind true joint tenancy is, if I own my home with my wife, in joint tenancy, if I were to pass away, there's an automatic survivorship, meaning that my spouse, as the surviving last owner, will inherit that asset directly. So she becomes full beneficial and legal owner of my home.
Right.
So in that case, my home, the asset, is distributed by virtue of this joint tenancy designation. It's not distributed by the terms of my will. So it's one way to distribute wealth or pass on wealth to others outside of the will. Now that has lots of pros and cons associated.
I was going to ask for that. Yeah.
Yeah. So as a general comment, what I would say is that joint tenancy, true joint tenancy, as I highlighted just now, is great for spouses and common law partners. Where I would caution Canadians is where parents start to place assets in joint tenancy with adult children.
Right.
So the common thing we see is, elderly widowed individuals who start to put, their home and their investment assets in joint tenancy with one or more of their adult kids. So in that case, if you have anyone who's thinking about doing that or have already done it, if they haven't already, they really need to ensure they get proper legal advice to really identify what it is that you as a parent are wanting to achieve by naming your kids on as a true joint tenant. So as we talked about, there's the true joint tenancy, but in law, there are actually other types of joint tenancy. And that could, without planning, can really create some problems in the estate. So again, just caution when you're using joint tenancy with adult kids.
So that old method that everybody's heard about, where like you said, the widow or is writing everything joint and they go, well, we're all looked after now. It could open up a lot of problems with
Yes.
creditors and things like that down the road.
Well, yeah, and Greg, I mean, what we find is that Canadians love joint tenancy, right? Like, and they assume that that's sort of the be all end all to their estate plan. And you know, it's like I said, it's great between spouses, but as you had mentioned, there's some potential landmines that occur when you start to use this with kids. And so you really want to, you know, parents have good intentions, but there are these underlying landmines that could creep up once they're gone that really can create litigation, disputes, and a lot of family discord.
Right. You mentioned earlier about business owners and passing and maybe the son or daughter not being ready. Maybe you can touch quickly on trusts.
Yeah, absolutely. So, you know, another way to pass on wealth outside of your will is to use this idea of a trust, um, uh, what we call a family trust or an inter vivos trust. And all that means, Greg, is that you're creating a trust during your lifetime. And whether that's for a business or not, a Canadian can consider using a trust, which is really just a separate legal entity that separates the management and the control of the asset. So if you place an asset into a trust, you are no longer the legal owner of it, but rather the trust is. But it does provide you with continued access to the capital and income of those assets in the trust. The idea here is that we name beneficiaries of that trust. And those beneficiaries could be family members, it could be a spouse, it could be kids. So you're really setting aside those assets and the future appreciation of those assets to your kids as beneficiaries of the trust. So when you pass away, the trust itself already provides all of the language and wording necessary to pass on that wealth to the kids. And it could continue on in perpetuity, or it could be wound up over some predetermined period of time. So that is another option for both business owners and non-business owners. And one of the primary advantages of that is to reduce some of the costs that are associated to your estate. We talked a little bit about income taxes, but there's also what we call probate fees, or what the name here in Ontario is an estate administration tax.
Right.
So this is on top of income taxes, and it's a fee that's charged by the Ontario courts to validate your will. But the fee is based on what you leave to your beneficiaries through your will. So if you can leave your wealth to your beneficiaries outside of a will, like using a trust or even through joint tenancy, because it falls outside of your estate, it isn't subject to this fee. So one benefit of utilizing a trust is a potential for probate savings.
Right. Just to kind of back up a bit, you said the language in the trust for audience, that would be controlling how the assets may be dispersed, who gets what, when. It could be typically in a trust, it's capital beneficiaries, income beneficiaries are named. So you could have a whole, you know, a few different generations benefiting from that trust, assuming obviously the assets put into it are large enough. And then, you know, that way, the issue that you brought up earlier, if you're feeling like one of your children is not ready to take on that much money at some point, you could have it kind of done over a number of years and then some capital distributed, et cetera. So lots of ways to position it, manage it, and it establishes the rules of when people get what is probably a good way to put it as well.
Absolutely. And by the way, you know, that's, you know, we're talking about inter vivos or trusts that we set up during our lifetime. You can also do this after you pass away as well by creating trusts in your will.
Okay.
Right? So that's another way. It's through your will, but it becomes effective when you pass away. And so
Right.
this idea of, if you have concerns around the kids spending through their inheritances, then instead of naming your kids as direct beneficiaries of your estate, you could also, as an alternative, leave those inheritances to a trust with the kids as beneficiaries. So it's instead of giving it to them directly, you're giving it to them indirectly through the use of a trust. And that way you can have a bit more control. Some refer to it as sort of controlling beyond the grave.
Right.
But it really allows for the parent to alleviate some of their concerns if they, for example, have spendthrift beneficiaries, or even just for creditor protection, and other really non-tax reasons to use it.
Okay. And that type of trust, it's called, correct me if I'm wrong, a testamentary trust?
It's a testamentary trust. Yeah. And the differentiation of that between a regular family trust is that it's part of your will. So it's language that's included in your will, and it becomes effective the day you pass away.
Okay. Gotcha. Tax and estate planning, obviously we've alluded to the fact that it's probably not something that people are doing. Some people are doing it effectively, but probably the vast majority of people are not. My feeling is that people shy away from it probably because they don't want to face their own mortality or the mortality of others. That could be one major reason why they may not want to look at tax and estate planning. And as a result, you have a lot of people, and you might have the stat, that don't have a will or have extremely outdated wills. And maybe you can talk about the stat if you have it available. If not, no worries. But also why it's so important to create a will.
Yeah, it's a great question. And, there are studies that are done every year or so that try to identify how many Canadians actually don't have wills. And every year, Greg, it astonishes me. The latest stat that we do have is that 51% of Canadians do not have a will. Wow. And, of the 49%, interestingly enough, of the 49% who say they do have a will, 25% of those say that it doesn't properly reflect their current wishes. So you've got a large cohort of Canadians walking around without a will, or with a will, but not worth the paper that it's written on.
Yeah, it's not going to do what they wanted. It's not going to achieve what they want to achieve.
Exactly. So that's concerning to me. And to really talk about how important it is to have a will is to think about, what happens if you pass away without a will, right? And by the way, this isn't just everyday Canadians. This happens to all sorts of people, and there's a number of celebrities, for example, that you would think have their affairs in order, but folks like Michael Jackson and Prince and Aretha Franklin all passed away with massive estates and didn't have a will, and it's created serious litigation and years and years of being in the courts to settle the estate. So it's really problematic. Because in most jurisdictions, like Ontario, so in Ontario, coming back to Ontario, it's really the Ontario legislation that will dictate how your wealth will be distributed. So they sort of have these predetermined formulas of how your estate will be passed on to beneficiaries. So you really have no say in the matter. Your family really doesn't have any say in the matter. And there's no planning. The courts aren't going to do any tax planning or try to save you any money in the process. So usually it results.
They might do the opposite, right?
They might exactly do the opposite.
Whatever works best for them.
That's right. And typically the costs associated with dying without a will is greater than the cost of actually going through the process of creating a will and putting into effect what you want to have done. So, this is what we refer to as dying intestate. So we have these intestacy distribution rules. And it's interesting, many Canadians will say, well, my spouse will inherit everything anyway. And that's not true. Yes, your spouse, if you only had a spouse and no kids here in Ontario, yes, that is true. But if you have children, then the spouse does not inherit everything. In fact, the intestacy rule suggests that the spouse would receive the first 350,000 of the estate. That's referred to as the preferential share.
Right.
And if you have one child, for example, then everything else gets split 50-50 between them. And if you have more kids, then the split is amongst all the children. So you have these preset distribution rules, and it's not ideal because you have no control in terms of who gets what.
Right.
The tax planning, as I mentioned, isn't there. So typically your income taxes owing will be much larger at the end of the day.
Right. You kind of touched on it a bit there, but if you die interstate, is there any, it either sounded like it was very difficult or not possible at all to challenge how the province would distribute your estate, or the heirs would be trying to challenge it. Can they do that? It either probably is very costly or not possible at all.
Yeah, I mean, anything could be challenged. And typically the process is that applications need to be made to the courts, right? And that's whether that's for a different distribution than what's determined by the intestacy rules, or even just having somebody appointed as an executor, for example. So if you don't have a will, who's going to be responsible for managing it? Well, the courts will appoint somebody.
Right.
And commonly that would be a spouse if there is one, but if other people can apply, and creditors of an estate can apply to be the executor. And they obviously have a financial interest in doing so. So it's just a much more time consuming process, and lawyers need to be involved in the applications. So it's much more costly and not ideal at all.
Right. It sounds like a very messy situation. And when you consider the time and cost to do it right the first time, which is go get a will, versus what you just described, getting lawyers involved, multiple people trying to be the executor, and the time involved, you probably just go get your will prepared and do it now versus hoping for the best down the road. Exactly.
And I mean, it seems like a daunting task, but working with yourself as a financial advisor, with an estate lawyer, it can be pretty simple. You can have some good discussions around who you want to act as your executor, and that really opens up some great conversations around who in your life do you trust with that responsibility, and who do you want to really speak for you when you're no longer able to. So that's a task that shouldn't be taken very lightly, and it's a decision that you need to make that is really will be important for your family and for everyone you leave behind once you're no longer here. So it's extremely important.
Right. Before we move on from this, I know I've looked at it in the past and kind of contacted a number of different law firms. And obviously it depends on the complexity of your estate, but let's say an average situation in Canada, I've seen prices to get a will and power of attorney for personal care and property care done, ranging from, let's say, maybe the low, like around $1,200, to as high as $2,500. What's your experience with that? Is it fair to say to people they should expect about $1,500 as a middle point, assuming their estate's not too complex?
Yeah, I would agree with that. And yeah, obviously every situation's different, and obviously also depends on, where you live and your region, that sort of thing. Prices will vary, but I would say that for, $1,000, wills can be prepared, and that may include, both spouses.
Right.
Again, and that could just be your simple will in a sort of simple scenario. What we call mirror wills, where sort of everything's left to each other between, say, spouses,
Right.
and then everything distributed equally to children, if any, with just basic language. I would say that's a fair comment, the prices you mentioned.
Okay. A lot of our viewers are from Ontario, but it wouldn't be uncommon to have people holding assets across borders. are there any major, or maybe not necessarily major, just tax and estate planning concerns people should have if they have foreign assets?
Yeah, that's a great question. And more and more Canadians are mobile and they're spending time in other jurisdictions, other provinces, other countries. They're buying up assets in other countries.
Right.
Obviously, during the 2008 recession, a lot of people bought properties down south that were sort of really cheap. So yeah, I absolutely believe that those scenarios where they're spending time, snowbirds, for example, need to think about their estate plan. And sure, an Ontario will, for example, may be used to distribute wealth in another jurisdiction. It is possible. I'm not going to suggest that it isn't, but it also could be much more time consuming and expensive. And by that I mean, your Ontario will, for example, would need to kind of go through the Ontario court system, be validated. You'll deal with your Ontario assets, and then it would need to be resubmitted in that foreign jurisdiction.
Right.
Let's say you have that Florida condo. Now Florida needs to validate that will, and the Florida, may not recognize an Ontario will, so could take up much longer to validate. So this whole process of distributing your Florida condo with an Ontario will, it's just not practical. It could be more time consuming. So the general recommendation in that scenario is to have a second will, and that's not uncommon. Many Canadians, they don't even have their first will. Now we're suggesting that they have a second will. But it may be ideal to actually have more than one will, right? And that's ideal in a scenario where you have assets in other jurisdictions. So the idea would be that you have your Ontario will, and it would deal precisely with the assets that you own in Ontario and where you live. And then you create a secondary will. Let's say you're using that Florida property as an example, create a will under the jurisdiction of Florida state that only deals with the distribution of that Florida property.
Right.
And obviously the two wills sort of need to work hand in hand and speak to each other to make it all work. But that just really allows for each will to be submitted to the courts and put into effect without any dependence on the other will. And it's much more cost effective. It saves a significant amount of time. And again, as Canadians just want to sort of simplify their affairs, that could be one way to do that.
Okay. And I would imagine that, these people we're talking about that don't have a will to begin with, they go into a good law firm and the discovery process is done where, what assets do you have? That lawyer's probably, if they're worth their salt, going to at that point recommend what you're saying. Look, we're going to create this will for your Ontario assets, but the property that you have down in the US or one of the islands or in Europe, we need to do this. And here's the reasons why, which is what you just kind of detailed.
And it goes back to our very first comment around, working with advisors, setting objectives, right? This is precisely it. So now you're going to work with maybe somebody who's more qualified to now help you create a Florida will,
Right.
or at least put you in touch with somebody who can assist you with that.
Mm-hmm.
It's all part of creating that plan that works for you.
Right. And speaking from personal experience, when I've got into those conversations with clients, things come up, right? All of a sudden you're like, oh, okay, well, how are we going to address this? And then we bring in experts like yourself, or like if we need to contact the lawyer and say, what's being done to address this? Like, what have you done a will for that property or those kind of issues? So it's all about communicating, having those discussions, planning, and without that, like everything, without proper planning, who knows what the end result will be. So.
That's right. And it's not just the wills, Greg. I mean, when you do your wills, as you mentioned earlier, you do your powers of attorney for property and for personal care. Again, the same documents may be needed in those foreign jurisdictions as well. I would in fact say that the powers of attorney maybe as important, if not more important than the wills, because in some cases we've seen, for example, a snowbird who spends time down south, and unfortunately has a medical issue that has to be submitted to the hospital in Florida. And if it's severe enough that we need the power of attorney to act on their behalf, it's very rare that a Florida hospital would recognize an Ontario personal care document. And so it really creates issues. And this isn't just for people who own property in other jurisdictions. It's those who spend time there. So even the snowbirds that rent down south, right? It's even good for them to have personal care documents created in the jurisdiction that they're spending time, so that those documents can be recognized should an issue arise.
Yeah, that would be terrible, obviously, thinking that you have something in place and as a loved one, you're going in and presenting it and they're saying, we can't, act on that. We can't acknowledge it because,
right,
or for legal reasons.
Exactly.
So good point. As I mentioned at the beginning of the podcast, the year's flowing by. We're quickly approaching 2022. Do you see anything coming down the pipe or on the time horizon with respect to taxation, estate planning that we should be, maybe it's nothing concrete yet, but some changes that might be coming?
Sure. I mean, we've now just been through an election, and there's a number of election promises that have been put forth by the Liberal government. So nothing has formally been proposed. A lot of discussion in terms of taxation, things like increasing taxes, potentially taxes on our principal residents. So there may be something. I would say more on this is forthcoming, probably in budget 2022, which happens around March and April.
Okay.
So really tough to indicate what's coming next year from that perspective. From an estate planning side, though, the pandemic has actually accelerated some things. In February of this year, Ontario legislation has put forth some new rules that allow for witnessing to take place virtually. That was something that wasn't possible before. So now we can create a will, and we can't use the pandemic as an excuse to have our wills done. We can have witnesses witness those wills virtually. Can't sign our wills virtually. We still need to sign our wills in wet ink. But virtual witnessing is now possible. A second change that's actually coming, and this was one that has created a lot of issues in the past. In the past, if you were to remarry, any existing will created prior to marriage was automatically revoked, meaning that it wasn't good anymore, and you actually had to go forth and create a new will. So starting on January 1st, 2022, marriage will no longer revoke a will, meaning that if you had a will in place prior to marriage and you remarry or get married, then that will is still effective and it's valid. Having said that, that's a major life event, and marriage is a major life event, and it necessitates a need to possibly review that will to make sure it's current and properly reflects your wishes. So it'll be a good time to update it if necessary, but at least we know that it's valid, and you don't run the risk of passing away intestate.
Okay, and that is effective January 2022. So prior to that, up until then, the old rule applies.
Correct.
Okay, very good. Well, it's always a pleasure. I'm happy to say that we are very fortunate to have someone like Frank in our corner when we're talking about tax and estate planning with clients. And partnering with Frank and Mackenzie Investments is always a positive to our practice. So I will remind viewers to you can link up with me to view this podcast. You can watch it on our YouTube channel. It'll be posted on SoundCloud as well. And if you do have any questions for myself, please reach out to me. And obviously, if I don't have the answers, I'll go ask Frank. So
sounds good.
Thanks, Frank, for your time, and wish you the best to, I guess, this happy Thanksgiving to you and your family. and we'll talk again soon.
Thanks, Greg. Thanks for having me. And again, have a great Thanksgiving as well.
Thanks so much.